All right, everybody. It is season 2, and Eric, don't even bring up how did we get to season 2? How many episodes does it take? Stuff like that. I don't want to hear it. But it is season 2, and it's episode 1 of Coffee Compliance and Chuckleheads, and we are back. Eric Rubenstein, Jordan Johnson, and me. I am extremely excited to be back live, not in person, but live with my two buddies. What's going on, guys?
It's good to be back. It's good to be spring break. It was good. Jordan, I don't know if you know, but Jordan actually spent a little time in Tijuana. The reason why he wasn't around is he was busy. He was locked up. Tijuana spring break. He lost his mustache.
I know. I'm missing the hair lip.
There's no more push broom. The push broom is gone, ladies and gentlemen.
The push broom is gone.
I miss Mario.
Battalion or his cart.
A little bit of
my
both.
gosh!
But,
listen.
Gone.
Listen, it's been
so
weeks since we've been able to abuse you. So just
it has, and you just gotta take it.
I got a lot of bent up coffee related frustrations I got to get out. There's so much to talk about. This is killer.
There is, and I am so excited. Honestly, I got to hang out with Eric Rubenstein for 4 days at the HCCA conference in Phoenix, Arizona. But even better was the fact I got to hang out with Jean Marie.
Yeah, the CEO of Advise. You got to hang out with my boss. That's a good time in itself, right there. I mean, hanging out with your boss.
The CEO of you.
Yeah, I was gonna say you get to see where those levels got. Yeah, that's exactly right.
Yeah, that was a good look. Anybody who was at the HCCA, I mean, we had a great time, right? I mean, I wound up doing 3 presentations. We put in for a whole bunch. I did one with a great lawyer that I do work with, that I worked with when I was at the OIG, and she was part of the Federal Monitor on the U of D and J case. Lisa Taylor, you got to meet her.
It was a great session. Lisa Taylor is phenomenal. Absolutely
awesome.
Love her.
Right. So we had that, and then 7 a.m. Jean Marie and I do a presentation with as advised people, and we thought nobody was going to show up at 7 a.m. in Phoenix. There were 2 other presentations going on. We wound up having about 100 people in the room and 300 people online. I couldn't believe it. It was so humbling.
It wasn't for you, Eric.
It was not for me. No,
it was not.
It was for Jean Marie.
Of course not. But then, my third foray is Sean had to do a presentation on behalf of Doctors Management and asked me to jump in and help out a little bit. And I was glad to stand there for backup and support and stuff. It was great. The HCCA conference, there's a lot of stuff that comes out of there. I think that there's a lot of good stuff. I think there's a lot of stuff that can be a little bit better. I found a few things where people were consistent in their misunderstanding of a few things, which leads me to say that it's not a misunderstanding by the people. It's the message that they're being given, right? Because not everybody can be giving the same message and be inaccurate. And for those that are watching, the one thing that I will continue to say is when the UPIC is submitting a letter to a provider requesting records, that is not an audit. It is an investigation. And everybody talked about the UPIC audits. And I just kept correcting everybody and saying the UPIC is working in a quasi governmental position. They are working in a quasi investigative role. And when they are requesting records, they are not auditing you. They are conducting an investigation based upon some issue that they have identified, whether it's proactive or reactive. And I think people need to understand that without spending a lot of time talking about it. I think people just need to understand that if you're talking about a UPIC review, it's an investigation, not an audit. I just did a great podcast on my retro podcast with Lori McMillan, who's our subject matter expert. She worked at the UPIC. She did these. She's one of only a handful of people who was authorized by CMS to testify on CMS's position. And we talked about UPIC prepays. We're going to talk in the future about post-pays, but I think, and we talk about it here all the time, that there's certain monikers that are out there and terms that are just incorrectly used, but it's because it's become sort of the de facto standard. So, we're going to hopefully clear a lot of that up as we get along.
Well, it was an awesome time out there in Phoenix. I enjoyed getting to meet so many people that say they listen to the Compliance Guy podcast. They follow Eric, Jordan, and I on Chuckleheads, and it really was. It was just a treat to be out there with all of you, and uh, I was so excited. I wish I had more than 60 minutes to do my presentation because obviously Eric and I we could have talked for a day on the stuff that we were talking about with data analytics and investigations and OSIG and, CIDs and pre-CID letters and all these incredible things that we're working on. It's just unbelievable. Um, I'm getting ready to head out tomorrow. As a matter of fact, I got to head to Palm Springs with Amanda Wesh of Brennan, Manna, and Diamond. She and I are going to be doing the keynote address at the California Orthopedic Association. So we are extremely excited about that. A lot of fun. Jordan, I know
I'm in the conference, man.
You're at the conference right now. Where are you?
So we are in St. Pete. We're at the National Association of Proton Therapy. Lots of information on health policy changes right now. We know there's some new models that are going to be coming out. CMS, CMMI are going to be abandoning some of the alternative payment models. So looking forward to what's coming out in the July release from CMS. So it should be interesting coming up for the proposed rules. So
yeah,
good times.
Well, we've got a bunch of folks on already. I am so excited. Samantha Patterson, we're excited to have you. We're so excited to have you here with us, and we're going to be talking all about the telehealth stuff here just in a moment. Hey to Pam Vanderbilt. It's good to see you, my old friend. Not that you're old, you're just an OLE, as we say here in the South, right? Our old friend. All right. So with that said, I went back to Samantha. Hey. All right. So why don't we start by talking about a politically charged issue? Because it's after 5 o'clock and this is our show. And the truth is, this is something that is really, really serious and significant because it's not only having immediate impact on the nurses and nurse practitioner profession, but it's going to have a long-term impact, in my opinion. Eric, Jordan, I think you guys would agree on this, right? And we have not had an opportunity to talk about any of our positions on this. So, that's one of the things about this program. This is not scripted. We're not having conversations prior to going live where we're like, hey, let's all get on the same page. I have no idea what's going to come out of your mouths, and you have no idea what's going to come out of my mouth. So I'm just saying. Here's the deal for those of you that are not familiar with this. So I believe it was in 2017, if I'm not mistaken, that a nurse at Vanderbilt administered a muscle paralytic as opposed to providing Versed for the patient, which is a sedative, right? And immediately following this, there was unfortunately no monitoring of the patient's breathing. There was no monitoring of their, what's the word I'm looking for? Their
vital signs.
Their vital signs. Good God. See, it's after 5 o'clock, and I swear this is
The Walking Dead. It's The Walking Dead.
She handed the patient off to just be kind of monitored by one of the PET scan techs and kind of left him in there. Yep.
So obviously, what happened with this 75-year-old patient is that they expired. The drug, created a paralytic effect. It paralyzed the breathing. It paralyzed muscle function, and ultimately, unfortunately, this 75-year-old patient passed. Now, the debate that's going on out there, and I want to get you guys' take on this, okay? Jordan, pay attention. We're on air, buddy. All right. Here we go. So what happened was what? The individual originally, the nurse Vaught, originally they were talking about having her brought before the nurses board, having this a board issue and letting the board determine what to do. Now, they reviewed everything and the board never made any recommendation to strip her of her nursing license at first. Okay. The case then went to the district attorney in Nashville, who then determined that they did not want to handle this as a civil matter or as a medical board matter or a nursing board matter. And they decided to prosecute this 30-something-year-old nurse, 36, 38-year-old nurse, under a criminal charge. I believe it was involuntary manslaughter. And she now...
I want to double check that because I think
So it's negligent
homicide.
Negligent homicide. But I think, I think we got to give a little bit of the backstory on the facts. So if I recall correctly, there was an issue with the machine that dispensed the drug.
So yeah, the Pyxis machine.
And that's what triggered a lot of the sort of the failures, right, Jordan? Because we talked about this pretty extensively.
Yeah. They had a Pyxis machine failure, but the staff had been taught to bypass that Pyxis, right? So this goes under the radar and really gets circumvented for like 10 months. It gets brought up and then becomes, to Sean's point, a CMS issue where CMS is going to investigate, and now all of a sudden the facility can lose their reimbursement, right? So now it's an issue. Now we need to prosecute somebody. And that's really, to where Sean mentioned, that's where this case picks up.
Right. So long story short, this nurse, Vaught, is found guilty by a jury of her peers, which, by the way, consisted of a nurse and another healthcare professional. They didn't say what this individual was. Now, there has been a massive backlash to this across the country, okay? And I get it, and I don't, right? So I'm one of those who's kind of sitting on the fence right now, because I understand both sides, right? Obviously, a significant mistake was made. There are other nurses out there saying that there's no way, with all of these precautions that you're supposed to take and all of these secondary checks and all of these different things that are supposed to happen, there's no way that a competent nurse would not make would make this mistake. Now, again, so anyways, and it's interesting because now on the petitions that have been signed, there's 190,000 petitions or 187,000 petitions, for clemency. And the governor of Tennessee has basically said, listen, sorry, unless it's for somebody who's on death row, I don't consider clemency cases. I leave that to the parole board to review these cases and make, recommendations on parole for individuals. Now, the part that I understand that nurses, and I know we have a lot of nurses that are listening to us tonight, and they're going to be listening to us on this podcast, and I empathize with all of you. And my point to this is this finding of negligent homicide is going to create, I believe, more individuals withholding information when a mistake is made. Because if you look at the facts of the case, Nurse Vaught came forward and admitted, I made mistakes. She took full accountability for everything that she did. The question becomes, should she have been prosecuted criminally versus allowing this to be a civil matter, and whether or not, whether or not it should have been handled by the nursing board.
Part of the metric is that there's this reckless disregard, right? Which is the lesser, which is why she was charged under the lesser charge. And I think the problem is that it implies that she had a reckless disregard, meaning that she should have done something that she didn't, right? And the problem with that is there was a system that was in place that wasn't operational. It was known to not be operational, right? I think the facts bore out that everybody was doing something to circumvent this system that they knew wasn't working. And at the end of the day, the drug that she should have gotten was a narcotic. So like, how is that even, how do you even get to circumvent a machine to do a narcotic?
So what liability does Vanderbilt have?
So
I
at
think
the end of the
that's
day,
that's
that's the question.
that's the question. And guys, so I'll say this as a clinician. I've done about 7 investigations for misadministrations with the Nuclear Regulatory Committee, also with sentinel events where patients were paralyzed due to wrong doses. And we've done these investigations. And to Eric and Sean's point, the big event never just happens. There's always red flags, right? So she circumvented the machine. There was a red label that said paralytic. It was in a bag. She noted that it was odd that it was a powder because we all know that Versed is a liquid. So, I mean, tons of flags. So I believe there's definitely liability there, but it depends on how you look at this. And the jury of her peers was only looking at her and her actions, not the environment that she was in. I think there should be a separate case brought up to the environment, because anybody that's clinical will tell you that, they're not surprised that this happened. What they're saying is, I can't believe it wasn't my institution, right? And it happens. We understand this.
I think that's an awesome point that you make, Jordan. Look, obviously, there's grounds for appeals, right? And I'm guessing we have not heard the last of this case. But again, for me, my big fear, not only as a regulatory officer for various health systems across the country on providers withholding information out of fear of what could potentially happen to them based on how the Vaught case went, but also as a consumer of healthcare services, right? It makes me concerned that there are these systems that are in these hospitals where clinicians are able to circumvent the system, bypass, the fail safes that are in place, and, potentially be administered something that I shouldn't have been administered. I mean, am I overthinking this?
No. The thing that's interesting is, without crawling into her brain is clearly thinking one thing, but the tactiles are telling her another, right? So she knows, she's been a clinician for a while. Versed is a liquid. It comes out in a powder. That's a red flag, right? So, the problem is that I think that, unfortunately, a lot of the processes that are in place that are in a lot of these environments are very mechanical, right? And so you don't really consider, like, it comes out and it's a powder, it needs to be reconstituted. Is she really thinking about it? Oh, it's a powder, it needs to be reconstituted. I am typically seeing Versed being a liquid. It's almost like, I remember when I was an EMT and as an advanced EMT, and I'd be on the truck, if somebody put equipment in a different place, you would immediately know, because you were always used to going, right? I go into this bin and I should be pulling out this size gauze and I'm pulling out this bandage, and you immediately know. And that's the thing that kind of perplexes me, is that she's doing this on a daily basis. She knows what these things look like. It's like a pharmacist, right? A pharmacist always, the pharmacy techs, they always know when they pull something off a shelf that doesn't look the way they're expecting it, right? Your brain is going in one way. It's like years ago, remember clear Coke? In the 80s, Coke was clear for a short period of time, and it was just a mind blow, because you've got this, you think you're going to taste it, it's going to taste like Sprite, but it tastes like Coke, and it went off the market because nobody wanted to deal with something that didn't look like what it's supposed to taste like. And I think that's the same thing, and I think that's the problem here. Now, does that rise to the level of criminality, or does it really stay within the realm of professional standards?
Go ahead, Jordan. What were you going to say, buddy?
No, I was going to say, I mean, it's the system we've built. We've built this checkbox system where it's very robotic, and we have timeout procedures for everything that we do. But also, a lot of these reporting systems, to Sean, are based on near misses. We report all near misses to better learn from this. Well, if we know this can happen, let me assure you, the number of near misses reported just went through the floor. They're not going to get reported. I mean, people are not going to report.
But does this then fall, like, so in the criminal statute, where they're talking about like a reckless disregard, I would surmise that the evidence of reckless disregard are exactly the things we're talking about. The drug came out, it has a red label, it's a powder, like all of these red flags that you're just disregarding them goes to that level of recklessness. That's
Sure,
right.
and that's exactly what the jury looked at. I think all of us that are clinical, all of us that have been around healthcare, we're all screaming, okay, now what's the next level at the Vanderbilt, the bigger level of the hospital, to say that this was something allowed this to happen, right? Now, I think none of us disagree here that she's responsible, and she clearly did things that were systematically subverted and she ignored. No doubt about that.
Yeah. And so maybe, again, if there's any attorneys out there tonight that handle criminal law, to Jordan's point, do the things that she subverted or the things that she circumvented, do those rise to the level of criminality? Again, this is something that is, and it's really a shame because this is being so politicized, as you can imagine right now in Nashville with individuals who are
Well, they
running
had
against
they had
the DA
nurses.
who's up.
Yeah, they had nurses do walkouts, Sean. To your
Yeah,
point, at that hospital, they had nurses do walkouts
yeah,
because of this case. And Sean and Eric are way more law opine than I am. But we used to have a, a, a policy, basically, or a law that was respondeat superior. The master speaks for the servant. And what happened to respondeat superior in this case? Clearly, it did not. They went directly to the individual.
yeah. So, to one of the lawyers who I know is on, and here he is, in his opinion, he does not believe this was a criminal case. But again, it got there. And, fortunately or unfortunately, depending on what side of the aisle you sit on in this case, and I'm not talking political aisle, I'm saying what side you sit on for the victim or for, and I guess you could say Nurse Vaught, in a sense, was victimized by the system as well. But obviously, my heartfelt sorrow goes out to the family of the deceased. I mean, this was a terrible mistake, but again, did it truly rise to the level of criminality? And again, I think the attorneys that are listening, at least one of them has said so far doesn't in their opinion. So, anyways, I think it's going to be interesting to see what happens with this case. Obviously, we're going to stay on top of this thing. We'll bring you updates as they become available to us. And with that, Eric, Jordan, anything else on this one before we move on to another hot topic?
No.
Okay.
Nope. Let's go.
Let's do it. What do you think about local coverage determinations and the fact that people are declaring these as legal documents? I'm gonna start with you, Eric.
So I know you have really strong opinions on this, and at least one of the lawyers that we're working with on a project, Robert Lyles, has a very strong opinion of LCDs versus NCDs because they miss they miss the key component of something being having the effect of law, which is being published in something like the Federal Register, but really, the comment period and all of that. And we know that during the previous administration, there was some commentary on LCDs just sort of being a document. And so, how do you take an LCD and try to enforce it when the previous administration had a position? And you can always go back and say that was then, this is now. But I think that a good legal argument on an LCD is going to be this is just, it doesn't have the effect of law. Now, where I would argue against that a little bit is if the LCD mirrors the NCD and is really just a recital of the NCD, they're really doing nothing but just white labeling what is already in existence, right? And so, if an LCD is something that is narrower than an NCD, and there hasn't been, comment and rulemaking process and all of that, and it's really nothing more than it's a max opinion of whether it should be covered. And the one example I always love to give when I was an OIG agent is I had a case involving a provider who was on the border of Pennsylvania and New Jersey. He had an office in New Jersey, he had an office in Pennsylvania, and one MAC covered the service that he was doing, and another MAC didn't cover the service. Now, what he was doing was fraud either way, it didn't matter. He was committing a fraud. But the important part of this was that you had two Macs that were literally he was on the west side of Trenton, New Jersey, and had he just paddled across the river to Morrisville, New Jersey, there's a bridge that's about this big, and you cross that bridge and you're in a different MAC jurisdiction.
Right.
Same service, same HCPCS, same CPT, same everything. Now, what he was doing was fraud, so that's a separate issue, because that's not, but the fact that there was a coverage policy in place in one and a non-coverage in another, my AUSA, my assistant U.S. attorney, was like, we better make sure that what he's doing is committing fraud, because how do you explain to a jury how a national program like Medicare isn't nationally being administered across the MACs?
Okay. So I've been biting my lip. I've been moving around in my chair. I've been getting ready to strap myself down into the chair because I felt like all systems were ramping up. And Eric, yeah, I'm with you. And Robert Lyles, I'm going to get to you in a moment, but I want to start with your old stomping grounds, the Office of Inspector General, who actually performed an audit back in 2014 and talked about the fact here there is a significant disconnect in a lot of areas between the MACs. So there's a lack of consistency from MAC to MAC, region to region. To your point, as you were talking about, one of your clients was just across state lines, right? So again, this is the Office of Inspector General coming out and specifically saying, listen, Medicare, CMS, you got a problem. And your problem is you have a lack of consistency in your local coverage determinations. But more importantly, under the law, these are supposed to be put through a formal rulemaking process in order to be promulgated into the law. You're required to have a 60-day comment period. So when I hear people talking about the fact that, and especially in an audit appeal, right, or in a hearing, and I hear people talking about the fact that, they're following LCD guidance because that's based on statute or regulation or law. I say, hold on a minute, time out. Now, I do want to say this, okay? Please do not turn this show off at the end and go back to your peers and say, the Chuckleheads told me I don't have to follow any of the guidance in an LCD. That's not what we're saying. What we're saying is they're guidelines. They are recommendations. And without them being promulgated into the law, without them going through a formal rulemaking process, you have a problem. Okay? So, a couple of things that I want to talk through, right? So, one of them was Jeff Sessions, who under the former president was the attorney general. And the Sessions memo was basically created to level the playing field, if you will. What it did, in my opinion, is it took the arrows out of the DOJ's quiver to a certain extent, because they said in a charging situation, you're not able to use de facto guidance as law. You cannot substitute something that has gone through a formal rulemaking process for something that is de facto guidance. And that really impacted a lot of the prosecutions. Now, there was a case in 2019 that's called Allina. And the Allina case basically has set forth now a precedent whereby, and let me share this with you. This was Azar v. Allina Health Systems. And what happened in Allina is that the courts basically came out and said, look, here's the deal. We're not in agreement with HHS on this because the ability for a practice or a health system to put in place the necessary changes to comply with a substantive change to the law have not been provided. And when you're not provided that opportunity, you have, and you push forward with an LCD that supersedes a prior one without any comment period, without any notice, that is not a formal rule. So real quick, to Robert Lyle's point, in Azar v. Allina Health Services, here it is. The U.S. Supreme Court held that guidance issued by CMS to its contractors is non-binding interpretive guidance. Period. It's non-binding. That comes from the Supreme Court. And to further what they were talking about, again, the CMS chief legal counsel issued internal guidance. And again, this is internal guidance. And he even said, this is not law binding. This is not binding. Okay. Where he warned that as a result of Allina, government enforcement actions based solely on LCDs are not going to be enforceable. So I think, and I could be wrong, you guys let me know your thoughts on this. I think there are potentially a number of False Claims Act cases that are the government's going to look to try to find a way to settle these to keep them from going to trial. I think that's my opinion on that. Because if they're going to rely solely on local coverage determinations and they're going to say that the practice violated the LCDs, okay, what did they actually violate? A guidance document? It's not law. Eric, Jordan, let me mute myself because I could keep going about this forever.
I love it, man. I mean, I think the LCD is, everybody's so quick to refer, and like it's almost like what Eric said, the misinterpretation of the audit versus the possible review. They just associate it's law, right? We know that it is a recommendation when it comes to billing, what may be coded or something like that. But I think it's just people are very quick to say it's the law, and it's technically, when you boil it down, did it go to the 60-day comment period? Was it filed? Was it proposed? Then was it finalized? That is what then becomes law. And I think it's just a misinterpretation that's been accepted for so long.
What say you, former special agent?
Yeah, it's a challenge. I think the discussion for me is, if we're talking about something that's on that cusp, the U.S. Attorney's Office from the criminal side, if we're talking about an LCD, we're typically talking about the medical necessity of a service and a condition of payment for that service. So to really get over that threshold of fraud, you've really got to show some sort of a plus factor there, right? Like, it wasn't just a medical necessity, like this patient didn't need this service, and there's some other defining thing in which, the record is not otherwise able to articulate or something. I always like to default to EKGs because everybody understands that. It's the simplest thing. You go to the doctor for a sore throat and the doctor does an EKG on you and it's fully documented, right? Doctor says, well, I'm going to interpretation and report, and they do it. Well, you've got a fully documented record, but it doesn't mean that the program should pay for that there's a lack of, no one is talking about the medical necessity from the clinical piece. They're saying the documentation is not supporting this as a service. And I think that's where there's going to wind up being a lot of this going forward. A lot of these discussions is going to fall upon where that LCD is. I mean, I could tell you as an agent, the very first thing when I got a healthcare fraud case that involved the provision of a service outside of a service is not rendered or an upcoding, but
right.
The one that I was talking about had to do with, he was a podiatrist, and what he was doing was he was billing for enhanced counter pulsation, ECP. There's a G code, G0166, I think is what it is. And it's really for patients who have unstable angina who are not eligible for surgery. I did a whole bunch of those cases when I was an agent. He was a podiatrist. It was totally outside of what he could even be doing, but it was a way for him to bill for it as a service. And so does the LCD come into effect on something like that? Yes, it comes into effect in the sense that in order to bill for this service, the patient has to have these conditions, But more importantly, it's by the way, you're a podiatrist. The last time I checked, people's hearts weren't in their feet. They can't have unstable angina. Boom, it's a fraud. So I think there's a discernible difference.
Right.
But what if we take that same scenario, but now it is a cardiologist,
Right.
and the cardiologist has is rendering this service, and it's inconsistent with the payment conditions per the LCD, but he has some colloquial evidence. It's almost like when you look at a Part D drug. Medicare doesn't pay for drugs that are off-label, but the caveat had always been that if there was some clinical evidence of that off-label use, and what were the sales reps doing? The sales reps were bringing up things that appeared in the compendium.
Well, let me take it one step further, right? Because there's another case, and I think this case is equally as important to Allina, right? And this is the Agendia v. Azar case. And in this case, the plaintiff, which is Agendia, they were a certified Medicare laboratory supplier, basically furnishing molecular diagnostic tests for the treatment of breast cancer patients. And when the claims were submitted, now keep in mind what I just told you, these are molecular diagnostic tests for the treatment of breast cancer patients. When these claims were processed, originally they were denied due to a lack of medical necessity. The claims were then appealed through both the redetermination and the reconsideration levels, and they were upheld as not medically necessary. Now, excuse me, it got to the third level of appeal, which is the administrative law judge. The administrative law judge determined that the testing was absolutely medically reasonable and necessary. However, CMS decided to appeal the ALJ in their hearing, in their decision. And as a result, they overturned the ALJ finding. Well, and what they determined was that the appeals council was that the test did not meet medical coverage criteria set out in the LCD, which is to your point, Eric, right? It wasn't, they weren't addressing medical necessity. They were addressing whether or not it met coverage criteria. Okay. Now, the laboratory decided no way. They filed to the fifth level, which was district federal court. And what they basically said here is that they argued that an LCD does not establish, HHS argued, not the laboratory, not Agendia, but HHS argued that an LCD does not establish or change a substantive legal standard, and instead simply determines coverage in accordance with the reasonable and necessary standard. And that the government then asserted that because there is special process for establishing LCDs, separate forms that are neither the APA or those that apply to the LCD are bound in this case. Well, the problem is the court said, we disagree with you. And they found merit in the laboratory's assertions, agreeing that the Medicare Act does not allow the government to establish or change a substantive legal standard unless it's through the regulation. Now, I think one of the things that a lot of attorneys are going to come out and say is, Sean, the thing you have to keep in mind is in the Supreme Court case in Allina, they never defined the term substantive legal change. That is something that they're waiting for the court to still define. And unless it's happened, and I'm unaware of it, if somebody out there, Robert Lyles, if you're listening still, or if there's another attorney out there, please let me know. But again, I think the point that I want to make to all of our viewers, all of our listeners, is that an LCD is a guidance document. It is not law. The only way something becomes law is if it is promulgated. So here we go. Supreme Court, let's stand breast cancer test payment denial.
Yeah. So this is in January.
So this one went back in January. Okay.
Yeah.
See, this is why I'm glad you're here.
So yeah, so Ninth Circuit upheld the reimbursement denial. Supreme Court rejected a request to review Medicare's decision. So
okay. So in the federal district court, it was overturned in favor of the laboratory. It then got appealed to the Ninth Circuit Court, who overturned it and basically said, no, we're going to side with the government on this one, and we're going to uphold the denials for payments. Yeah, I agree. That's the Ninth Circuit. There's no doubt about that, Robert. That they call it the Ninth Circus. And then it went to the Supreme Court, and the Supreme Court decided that they did not want to overturn the payment determinations that were put in place for denial. Okay, good. Well, look, this again paints a picture for me of the inconsistencies in the courts. I think that's what this points out to. But we still go back to the Allina case, where Allina was decided by the Supreme Court, and Allina made the determination, even though Justice Breyer wrote the dissent on this, that you cannot change anything without public notice and public comment. Eric, Jordan?
Yeah, these are interesting. These are interesting discussions. While we're sitting here talking, I'm feverishly Googling different things.
That's what I was doing. I was doing the same thing.
Yeah, I mean the LCD has been the standard. The day that I started as an OIG agent, they hand you a whole bunch of things to look at, a whole bunch of things that are all acronyms and what have you. But NCDs and LCDs become the standard that you look at in any case that involves medical necessity. And anytime I had a case that involved medical necessity, the first thing I thought of is, what criminal AUSA is going to take this case? And number two, what is my fact pattern to really show that this isn't really a medical necessity case? So such to the level of a medical decision, other than getting back to my kind of poor example of the EKG, where you just go and you go, this is someone who's just doing a test to do a test. Like, it's not there's no clinical argument. Like, we're talking about the BRCA test.
Right.
There's some markers, so to loop back, for those of you that are following me on LinkedIn, I recently went and had a CT scan for, calcium scoring. I have an extensive family history of cardiac problems. My father had a heart attack when he was 44. He had a heart attack when he was 76 or 7. He's had probably stents 4 or 5 times. He's on blood thinners. He's on anti-cholesterol drug. He's on everything. I have nothing other than 10 years ago, I had in a normal physical during an EKG, I had what was called an inverted T wave. They say in 80% of the people, it's a blockage. In 20% of the people, it's anomaly. I had a stress test. I had a nuclear stress test. They said, no, you're good. Now I'm going to be 54 years old. I go to a cardiologist here just for a checkup. The doc says, hey, we could do one of 2 things. We can, because you have this history, you have a diagnosed history, you have borderline high cholesterol. You can either go and get a stress test, or we could do this calcium scoring test. I said, well, I'd rather have the one where I don't have to run around for 20 minutes on the treadmill, which I'm fine doing. But the point is that they came back and denied it, saying there was no documentation in the record to prove medical necessity. And I read the record from my doctor because it's online. You can look at it. So we're appealing it. But I thought to myself, what more do you have to show? I've got a documented history of cardiac conditions in the family. So there's a family history. I've got the same insurance, by the way, I've had for years on end. So they could go back and they could look and they could see that I have an ICD-9 at the time that showed a diagnosis that needed this, that I needed the cardiac stuff. To come back and say it's not medically necessary, it's like, well, what does a guy have to do, around here to get a drink, right?
Yeah. Well, you know what the problem is?
I think that's the issue. I mean, we've made it so, and I wouldn't even say difficult. They've just created this process, and the process has lost all logic. And I think it's because the wrong people are involved. And I understand why they've done some of the things, but this stuff has to evolve. I think, quite frankly, that putting some of this to public comment may be useful. I don't think they would do that. I mean, you guys, Eric, you're old school. You and Sean, the Highmark days. I remember the Highmark days a little bit, but I think some of that would be useful for public comment. And I
date back to HICFA, to the Healthcare Financing Administration. But Eric, I'll tell you what your problems are. You're vegan. That's your problem.
So
I mean,
that could
my
be- that could be
triglyceride is
part of
like
it.
my triglyceride is
Yeah.
like 103. My total cholesterol is like 113, and
Yeah.
I slap the horns off a cow and throw it onto a plate, and there we go, man.
Well,
You
the
gotta-
problem is you don't realize it, but all of the running through women's brains that you do at night, it just keeps your heart fit as a fiddle.
Jeez. Oh my gosh. Oh boy. Well, the truth is I actually have 3 stents. So don't take any cardiac advice from me. I'm on statins, high blood pressure medication.
That's it.
So, yeah, don't take any cardiac advice from me. It'll be highly faulty. All right. Let's move on because there's another huge topic. There's so many huge topics. Telehealth. We got to go back to telehealth. What do you think about that, Eric?
Listen, let's call it. Let's instead of telehealth now they're calling it because it sounds better. Virtual health, baby. Virtual
Yeah.
health. So just change the name, just a different outfit, baby.
Yeah. So, if those of you that are on here today, tonight, listening to us, or if you're listening to the rebroadcast, you saw that I put up something that was announced today by the Office of Inspector General talking about CMS paying practitioners for telehealth services that did not meet the Medicare requirements. That was one of the audit studies or audit reports that actually came out from the OIG. But telehealth has become such a huge target that the Office of Inspector General has now created its own telehealth webpage that you can now keep up with. And I think this is a shot across the bow to all providers during the public health emergency that relied heavily on telehealth, or to Jordan's word, virtual health services, and who, following the PHE, have continued to utilize telehealth services. This is a warning shot across the bow. And Eric, you've done as much investigative work on this as anybody that I know. Terry Fletcher, she and I talk about this all the time on the hashtag Terry Tuesday that she does on the Compliance Guy. But you, Jordan, and I, we talk about telehealth and telefraud all the time. And before I wind you up and let you go, let's just clearly define these, right? Because telefraud is really dialing for dollars, right? This is dialing for dollars. These are typically, third-party vendors that have somehow gained access to Medicare beneficiary lists from one source or another, and they call and they're trying to sell them the latest back brace or elbow brace or knee brace or diabetic testing services or whatever it may be. Telehealth services are services rendered by a clinical professional, nurse practitioner, PA, MD, DO, who are evaluating a patient for a chief complaint, and they are making an observation as best as they can via, their telephonic device or their video interaction. And they are making a decision as to whether or not they can prescribe something for the patient, whether they tell the patient just go rest and ice it, or you need further evaluation. Come to my office, go to the emergency room, get to a critical care facility. Now, let's talk about why OIG is going after telehealth.
Eric, I'll defer to you, but before I defer to you, I'll say, to Sean's point, it is a warning shot. I mean, listen, virtual triage is huge right now in oncology, and it should be because there's a place for it. They have got to get the reins on this issue right now, and that's the problem. And I think that's what they're shooting for, is to quickly get it got out from under them. It got too far in front of them, and they're fixing to make some examples out of some folks. So, Eric, go for it.
Yeah, well, so first, when we were in Phoenix, I did drag Sean to a vegetable forward place for lunch. I did preface it by saying, "Are you okay having a vegetable forward lunch?" And he said, "Sure." That was his word. His word was okay. We took him to a place that was a vegan restaurant.
But in all fairness, wait a minute.
Shrimp.
In all fairness, when somebody says to me, "Are you okay with a vegetable forward plate?" Okay, right. Being from South Georgia, when you tell me vegetables,
don't think about fried. You think about fried okra,
mac and cheese, mac and cheese.
But I'm thinking about squash and zucchini
Yeah,
thrown
no,
in a
that's
saute
not.
pan with a pound of
No,
butter. Yeah, I'm okay.
you've learned your lesson that a pound of butter is not, well, butter is not. I'm really like a vegetarian, but I'll eat butter, but yeah, that butter is not vegan. So
And the truth is, you're only vegan when Jean Marie's around. So
that is
there's
true.
that.
I'm only vegan when the CEO of the company's around. I don't eat meat though. Otherwise, there's some chicken and fish. But yeah, but I'm
All right,
vegan.
let's talk about
I mean,
telehealth.
anyway. So look. The issue is that telehealth isn't going away, right? Telemedicine as a modality is not going away, and that's important because CMS has readily recognized. I think there was a recent study that said 84% of people who had a telehealth visit last year, or that where a telehealth visit was charged, 84% had a pre-existing relationship with their provider, right? So the 16% did not have a pre-existing relationship. And whether those are fraudulent or not, I think remains to be seen. But there's still the issue of the telefraud, which is the genetic testing, the DME, all of that, prescriptions, all of that stuff, where there isn't a bill that's being submitted, for that. But it's an important part of the health continuum. It's an important part of things like the social detriments to health, right? The social determinants, however you're calling it. But there's those Z codes, and for people that are familiar with that, there's no CPT code to document social determinants of health.
Right.
Or social detriments of health. There's no CPT code. These are Z codes that are really being done as part of a project through, I think it's a CDC. It's like the Healthy Americans 2030 or something like that.
Right.
But the point of it is that always remember, it's in the same vein why CMS will say you should submit a claim for services that you render, whether it's paid or not paid, because you need to have the understanding of things like advanced beneficiary notices, but also things that CMS doesn't pay for today, they may pay for tomorrow. And it's so a lot of this is statistical tracking and analysis that's done. And so things like these Z codes are kind of a unique thing as a project to be able to track these. But the use of telehealth is an important modality during the public health emergency, but even beyond. You've got these people who are elderly, they're shut-ins, they're not getting great health care to begin with. And so this becomes part of that ability for that chronic care management, the CCM. You're a diabetic, you're hypertensive, is someone checking to make sure you're okay. So it's important. The problem is that, whenever no good deed goes unpunished, right? So every time that CMS tries to come out with something that is meant to help to facilitate a healthier population of people, there's going to be the population of people that are going to capitalize on the fraud that's out there. Part of that is when Sean and I were talking earlier today, there is an OIG study that was just put out regarding a provider in New York, in Queens, who is an MD psychiatrist, is what I'm going to guess, because he's an MD.
That's right.
But he was basically running a practice that did psychotherapy sessions. And some of those sessions he had a whole bunch of problems, and some of them probably legitimate. He had some practitioners that weren't licensed in the state, but he had some incident 2 issues that were, a little on the odd side. So one of them was that during the public health emergency, his staff billed for telemedicine visits that were billed out apparently correctly as incident 2 services, but they have no way to be able to prove that the doctor was available via audio and video. Well,
right.
How do you prove that?
You can't.
I mean, how do you prove? I joked with Sean and I said, so is the doctor just sitting in front of his home computer surfing the internet, waiting for one of his staff to pop up and say, hey, doc, I need you? The other recommendation that the OIG came up with, and by the way, I did say that the doctor was surfing porn. I didn't say he was surfing
Come on,
the
this
internet.
This is a PG rated show, man. Come on.
So but there's truth in that, right? Like, what is the doctor doing that you can prove this ready availability in the absence of being in the office suite, which is the incident 2 provision rule?
Anybody could create that log.
Right. But the other thing, which is what we really talked about, was that one of the OIG's recommendations was that there be some sort of sign in and sign out log for the provider so that you could prove that the provider was there. And I said to Sean, when I was an OIG agent and we did these cases, the thing we focused on was when the doc was out of the country. His credit card receipts, his travel receipts, his passport swipes, the things that definitively show that the provider wasn't there.
That's a great point, because we get in that to audits all the time, and people get so outlandishly granular to say, do you have a check-in log? Do we know that Dr. A was actually in the building? And they want an in and out, like almost like a credit card swipe, like I'm in, I'm out.
Well, that's, and that goes to the other thing, right? Signatures, physician signatures. Folks, anybody could freaking put a physician's signature onto documentation. I get it, okay? I lecture about this stuff all the time. You don't have to tell me that the MACs have guidance documents on signature requirements. I know they do. But the point is, and a good friend of mine, David Glazer, who's an attorney out of Minneapolis, he always raises in cases the argument about, so what? The signature wasn't on there. It doesn't mean that the service wasn't performed. It doesn't mean that the service wasn't medically necessary, reasonable, and appropriate.
Technical violation.
It's a technical violation.
Which, by the way, the two technical violations that a provider should never get denied for: missing signature, illegible record. You can correct those with a transcript.
Yeah.
And an attestation on signature. So the two things that a provider could never get denied for. And I will tell you, if we ever had cases, when I was at the OIG, if we ever had a case where they would talk about like missing signature logs, illegible records, if it's illegible to the point where it looks like it's just a service that wasn't rendered, or there's some other factor. I remember looking at some stuff where the doctor would squeeze in a note, like in between two dates of service. So, it was a fabricated note because there was literally one sentence. Yeah. One line in the page, they would do it. But generally speaking, an illegible note, you can do a transcript. CMS has a policy that allows you to do a typed transcript with a signed attestation. If you are missing signatures, now with EMRs, it's very hard to do that. But there are still providers out there who are still pen and paper docs because they don't care about interoperability and all of that stuff. And so, it doesn't interest them. But to see that you're going to get dinged on something like that
it's
is
nonsense.
Right. And so when you're saying like, oh, you should have a sign in and a sign out log. Okay. So does that mean, am I rubber stamping it? Am I going to have my secretary, hey, I'm on the golf course today, could you sign me in? It's done all the time, right? People that work in restaurants are swiping themselves in and out, right? We do here at Advise, we do some physical, like IT security, like first level. And social engineering, piggybacking, getting in when people are swiping into spaces. How is that any different than signing a sign in and a sign out log?
I could never work for Advise. I'd be terminated almost immediately.
I do the same thing in the parking garage. When the gate goes up and the person goes, I try to go out with them.
Yeah, it's just to make that as a recommendation. You're like, are you?
No, I agree.
It's so form over substance, right?
It is.
What is your definitive proof going to be? I know. We would have these cases with nursing homes where doctors would come in and they would see the patients, they would do wave therapy and then leave, or in the hospital. And then you'd go back to the hospital and you would say, do you have a sign-in log? Or the SNF, do you have a sign-in log? And the SNF would say, yes, we do, but we don't really enforce it for the staff or the clinical staff. So you've got something you're not. So like, what are you going to do? And Sean, I know we have a couple seconds left, but from a compliance perspective, what do you tell people who have, where there's like, what are you telling them?
Don't do it.
Yeah,
what are you going to tell them? Seriously, look, fine. We're going to create a signature log, or we're going to create a time in, time out log, unless the compliance officer or the manager is sitting there watching it every second of the day, monitoring each and every single person who's signing in, signing out, whatever it is.
The other side's going to gripe about productivity, about how much time did it take to actually swipe in and out.
If I hear anything more about, I don't have enough time in the day. I love my physicians and providers, but if I hear them say, I don't have enough, listen, stop surfing on the internet in between every patient for 20 minutes. Stop showing up to the office an hour late. Stop leaving an hour early, and you'll have enough hours in the workday to get done what you need to get done. Now, that's not all providers. That's just a few that gripe to me all the time. Now, in putting a bow on this thing real quick, some things that we learned, right? So here's what we learned today.
In the compliance world, I always say in a world of no, it's more no.
It's more no. So here we go. Things we've learned this week. Elon Musk, if you encourage him to do something, he will do it. Elon Musk is now the largest shareholder in Twitter. 10%. Thank you very much. He said he was going to do something about it. And guess what? He is now appointed to the board of directors. Wonder what's going to happen with Mr. Musk and whether or not he's going to force a little more freedom of opinions on all sides. 2, we've learned we do not take any cardiac advice from Sean Weiss. 3,
true story. Or
3,
vegetarian advice.
Or vegetarian advice. 3, we don't trust Eric Rubenstein when he says, "Are you okay with a vegetable forward lunch?" But in all seriousness, we've learned again that LCDs are not law. Unless they've gone through a formal rulemaking process of open comment period, they are not law. They are de facto guidance documents that can and will be challenged by defense attorneys across the country. 2, we are continuing to advise all of our clients. You like that little advice? We are continuing to advise all clients out there that if you're going to bill for telehealth services, you got to do it the right way. You got to make sure that you are putting the proper attestations in there, that you are having the proper place of service, that you are notating the type of interactive or telephonic service that you're providing. Make sure that your documentation for a telehealth service should not be that much different than what you have if the patient were in front of you, with the exception of palpation and things from an objective standpoint, right? From a physical exam. You got to do the same thing. 3 things that you should always determine for whether or not a claim passes muster. 1, was the service reasonable? 2, was it appropriate? And 3, was it necessary? Those are the 3 things that I tell every single auditor that works with me and that I get a chance to work with. And anytime I'm in front of a judge, I tell the judge all the time, in order for me to say that this documentation that's in front of you, Your Honor, is reimbursable, it's because the service is reasonable, appropriate, and necessary, period. 3, the third thing that we've learned today is that Eric Jordan and I, we can't take any more vacations for the rest of the year because we have truly missed each and every single one of you that has been part of this program today. And the 4th and final thing that we have learned today is that we truly, truly miss Mario. And we want a return of Mario.
I'll grow it back, man. I'll grow it back.
Well, the problem is you started growing it when you were 11 years old. So
I know it looks, and then I will, and then it looks like I have mange like a dog.
Okay, so before this thing gets out of hand, I want to say on behalf of Eric Rubenstein, Jordan Johnson, myself, thank you all so much for hanging out with us tonight.
Sean,
yeah, please.
Before you sign off, the one thing I'll say is he talked about the signatures, and if you sign that signature in pen and it's in ink, that's basically a fresh print. That's the same thing that Will Smith left on Chris Rock's face as fresh prints. Oh.
And with that, I will apologize to our viewership. And I will say, folks, we will try harder next time. But I promise you, we will be back next week, and we will be back the week after, and we will be consistent with you moving forward. But until next week, as I always say, be good to yourself, but more importantly, be good to each other. Take care.